Hello, everyone. My name is Federico Tozzi. I'm the Executive Director of the Italy American Chamber of Commerce, and I'm very happy today to introduce my good friend, Nick Caiazzo from Wilson Helser. Nick has been, besides being a friend, has been a great supporter of the Italy American Chamber of Commerce, and his firm has helped us, many of our members, Italian companies operating in the United States. So I thank him for his efforts and for his support. So today we are going to talk about a very important topic. As you might know, food imports are one of the major imports from Italy to the United States. And I think we have a lot of members and non-members that might be interested in this topic. So it's always good to be up to date. And I'm going to let Nick take the floor and introduce the two speakers of today. Thank you, Nick.
Thank you. Thank you very much, Federico, for your kind words and introduction. And I do have to say thank you and your staff for the great work that you do in serving to help advance the interests of your members, companies, and professionals in all that you do, introducing companies together, events, and especially wonderful social gatherings. So thank you for all that you do. As a member of my firm's Italy practice team, I chair the team, and I have the great honor today of introducing two of our practice team members, Joseph Biacco and Daniel Trainin, who will present today on hopefully giving a better understanding of what the liabilities are for foreign companies that import food products in the United States. Briefly introducing Joseph Biacco. Again, he's my partner working primarily out of our New York metro offices. He's a true litigator, both in state court and federal court, practices in both jurisdictions, and also oversees many cases across the country, and also representing companies that have businesses in Italy. And we've personally worked together on some of those matters and know that he does an amazing job. Also, my partner, Daniel Trainin, who is our managing partner in our St. Louis office. He's also an amazing litigator, also has a national practice, handles mass torts involving food and food litigation. So I think both will be presenting very interesting information, and I hope that everyone enjoys their presentation. Thank you very much.
Good morning. Good afternoon, everyone. Thank you, Nick and Federico. This is a true honor to be here, and I really appreciate the opportunity to talk to everyone today about this important issue. As we get started, I wanted to talk to you a little bit about the presentation that Dan and I are about to give here. Some of the highlights to get started. We're going to discuss the exposure of foreign importers, manufacturers, to litigation in the United States. That would be mainly in the context of product liability litigation. We're going to talk specifically about food claims, but a lot of what we say is applicable to any product that gets imported into the U.S. So I think we should keep that in mind. It is a very specific body of law. It's different from some other law that you may have dealt with, whether it be general liability, trips and falls, auto liability, some of the things that come up in our everyday lives. It's important to keep track of, I guess, as we go through this, that there are some specific concerns with product liability and food claims, and more specifically with foods that are being brought into the United States from foreign areas, foreign countries. One of the areas that Nick mentioned that Daniel works in is mass torts, and food and product claims often become mass torts. When we talk about mass torts, we're talking about usually about litigation where it's not just one plaintiff. Sometimes it's a couple of plaintiffs, sometimes it's hundreds or even thousands of plaintiffs. And these are people that are claiming the same or similar injuries from the product or the food that we're talking about. So this becomes mass litigation, often coming from different parts of the United States. Somebody in California might be making the same claim or a similar claim as somebody in New York and someone in Missouri. And when that happens, these mass torts, as they become known, because there's many people making the claims, they often turn into what we refer to as multi-district litigation. That's something that'll come up during the course of our presentation today. A simple way or an effective way to look at multi-district litigation would be that this would be when claims are coming in from different courts, even different parts of the country, a combination of both of those things. Maybe one judge, one court kind of takes control to oversee the litigation and says, okay, there might be 400 claims from different parts of the country, but they're not going to be handled 400 individual ways around the country by different judges who have different rules and different ideas of how things should work. What they're going to do is one judge, maybe in one specific place, is going to take control of all. And that's going to be more of a streamlined way to handle the litigation, while also leaving the plaintiffs with their individuality. So they still have their individual claims, but it's going to be treated as a group because of the similarities. The last thing we're going to talk about today, I think, is, and hopefully we'll have some real time to do this, as much or as little time as we have left. We're going to talk about the Daily Harvest case, which we'll do a case study. This is a case that Daniel and I worked on together. And this gets into the first three items that we talked about here. This gets into foreign suppliers of food, product liability law, which we'll get into. And it also gets into something that became a mass tort and that was handled in a multi-district type of way. So as we get started in any presentation or any time that we're dealing with the law in the United States, especially for foreign companies, we first start to talk about jurisdiction. And the simple way to look at this is, does the court, or do the courts where this is based, where this litigation is brought, are they allowed? Do they have the authority to be the court where the litigation is held? Just because a plaintiff or someone who sues one of the foreign companies or even a domestic company brings a lawsuit in a specific court, it doesn't mean that that court is the place where the litigation is properly held. And a lot of times that's our defense. When you engage with us or the attorneys that you work with, the first defense we think of is, let's put our heads together with our offices in different parts of the country, and let's see, is this the right jurisdiction? Is there a choice of maybe another jurisdiction where this case could be brought, or these cases could be brought that might be more favorable? Maybe they have more favorable law for us or for you, for our clients. One of the concepts that comes up here often, and with foreign companies especially that are doing business in the United States, is in the second bullet point down on this slide. It's purposefully availing yourself or themselves of jurisdiction. What that usually gets into, the analysis there, did this company that imported food from Italy into the United States, did they purposely avail themselves of jurisdiction in a particular court? What that usually gets to is intentional acts. Did the company did the defendant, the one who's getting sued, do something to bring jurisdiction in a particular court? Did they intentionally import an item to a place, to a state, to the United States, to the particular place where they're getting sued? Did they intentionally do that? That's the product liability context of purposefully availing themselves. And this is often a really solid defense for foreign suppliers. This is something that we can say, hey, our client had no idea that this was going to get into this particular jurisdiction. They can't be sued here. An example would be maybe something that's being imported from Italy into Canada with absolutely no expectation that it's going to end up in the United States. No intent. The intent was something would be imported from Italy to a distributor in Canada, and that distributor in Canada distributes within Canada. And then the company in Italy gets sued in the United States. I think that would be an example.
So there are generally two major hurdles that a plaintiff must overcome in connection with establishing a court's jurisdiction over a defendant. First, the plaintiff must show that the state's long-arm statute can reach that defendant. And a long-arm statute is a statute that every state has, which defines what type of events generally allow for the court's jurisdiction over the person outside of the jurisdiction. And so for our purposes, that typically must mean that the defendant either entered into a contract in the state or involving the state, or that the defendant committed a tort or did something within that state that caused an injury. And second, the plaintiff must show that the court's taking a case against the defendant in that state does not offend traditional notions of due process and fair play. And for that standard, the court looks to see if there is some reasonable basis why the defendant might expect to be hailed into court into that jurisdiction based upon its conduct. And that's the purposeful availment that Joe was just talking about. And so if you're making a food product in Italy and you're selling a food to a food importer in the US, you might say, well, I'm not doing anything in the US or specifically in any particular state. And so under those circumstances, you might think that a court can never take jurisdiction over that company. And you might be right. But the US Supreme Court, and that's what this slide is about, has set up a separate set of rules to deal with products because of the often complex web of distribution that may lead a product ending up in a particular state. And this separate set of rules is called the stream of commerce theory. This rule generally refers to the movement of goods from manufacturers through distributors and sometimes importers, ultimately to consumers. And the underpinning of this rule goes back to that purposeful availment concept. Did you do something that means that you could reasonably be expected to be sued in court in that particular jurisdiction if things go poorly? The stream of commerce rule is generally unsettled, however, and it's applied differently across different jurisdictions, primarily because the rule has not been stated with consistency by the United States Supreme Court. And as a result, the application of this rule may make it either easier or harder for a court to take jurisdiction over a defendant who puts a product into the stream of commerce or who moves a product through the stream of commerce. Now, uniformly, if the manufacturer or importer or distributor actually puts the product into the state at issue, there's going to be jurisdiction over that company because you've acted within the state. But what about those who don't touch the state? Joe's example. The different jurisdictions are split between a knowledge version of the stream of commerce and a targeting version of the stream of commerce. For example, in Missouri, which is in the Eighth Circuit, if you're outside the state, but reasonably could anticipate that your products are going to Missouri because you've targeted Missouri as a place to sell your products, then a Missouri court can probably take jurisdiction over you. In fact, even if you have not specifically targeted Missouri, but you've set up a national distribution network, which targets all states, including Missouri, Missouri still may take jurisdiction over you. But if you've done nothing else to send your products into Missouri, even if you know that your products might end up there, then the court probably can't take jurisdiction over you. Meanwhile, in Texas, which is in the Fifth Circuit, if you have any reason to believe or know your product is being sold or marketed in Texas, regardless of how it gets there, then some Texas courts will find they have jurisdiction over you just based upon that knowledge. And it's only where the product ends up in Texas fortuitously or without any knowledge or planning by the seller or manufacturer or importer or distributor can those individuals reasonably avoid jurisdiction in Texas. And so it's a big difference, targeting versus knowledge. And even within those states, the law is applied differently or in sort of a blurred fashion because of the lack of guidance that's been provided by the US Supreme Court on this issue. And so while some states require active distributions into a state to get jurisdiction through the marketing of the product into that state, for other states, it does not matter. Knowledge is the key, not action. And so knowing which type of state you're dealing with and how it applies to stream of commerce theory is important for purposes of knowing whether you can effectively challenge jurisdiction. So let's go to the next slide. And so if you're a foreign distributor or manufacturer, the key, of course, is to try to avoid widespread jurisdiction. And then in order to do so, you have to plan for the lowest common denominator, right? Which is effectively knowledge. If you want to challenge jurisdiction everywhere, it's not only a function of whether you are directing the products to the state, but whether you even know if the products are being distributed once they get into the United States. So in Joe's example, the product is only being sold in Canada. It's only anticipated that it's going to be sold in Canada based upon the distribution to Canada. If it ends up in the United States, there's no knowledge, no expectation, no marketing. And in general, it would be very easy to make this jurisdictional argument. And if you're sitting in Italy and you're a food manufacturer and you're selling your food to an Italian exporter, which is exporting product to the United States, and you're not directing the marketing of the product to any particular state or any state at all, you might not be brought into court in a state like Missouri. However, if that importer is selling your food product to Whole Foods, for example, and then sending you reports about how many units are being sold in Whole Foods stores in Dallas and Houston, well, then you might be subjected to jurisdiction in Texas. And if you're not getting those reports, and you only know that the products are being sold to Whole Foods, but you don't know which states Whole Foods is selling your product in, well, then you might have a pretty good argument to avoid jurisdiction, even based upon the knowledge standard. So that's where the product ends up solely being sold in a state subject to the control of someone else. And if you're an Italian manufacturer and you sell your product to a US subsidiary, which sells the product through a national distribution chain in the US, and the Italian manufacturer knows where all the products are being sold, not only is the US subsidiary going to be subject to jurisdiction in all of those states, but the Italian manufacturer might be subject to jurisdiction as well. But again, if the Italian company sitting in Italy is not doing the national marketing and doesn't know the details of what its US subsidiary is doing, well, then it may have a defense. In another example, let's say an Italian company is shipping the food instead of to somebody in Italy, but to a port in the US, say the Port of New York, and the subsidiary takes possession of the food in New York. You might have an argument to avoid jurisdiction in most states, but you may be subject to jurisdiction in New York because you're actually touching New York with your activity. And so the risk we sometimes see is where the US subsidiary is argued to be a shell company and therefore what's called an alter ego of the foreign manufacturer. And that's the bullet point on the slide. And if the plaintiff can prove that point, and I'll tell you, it's not generally an easy point to prove, well, then the US subsidiary could effectively be considered to be an agent of the foreign manufacturer. And then the court could find that the foreign manufacturer has been operating in the US through its US agent. And we see this argument also made with importers. In fact, right now we're working with a company that has a foreign manufacturer, and it used an affiliate company with common ownership as the importer. And the argument that we think is going to be made is that they're alter egos. Now, again, it's a hard argument to make, but that's the kind of arguments you'll probably see if you are a solely Italian manufacturer. You're operating only in Italy, but you're working with affiliated companies that are operating in the United States. And that's how the plaintiff's lawyers will try to get to you. One way to protect is certainly to avoid this alter ego argument is to follow all of the corporate formalities. If you're a parent and subsidiary, if there's a clear corporate delineation between the two entities, and one isn't really a shell of the other, but they're following the corporate formalities, that makes the alter ego argument much harder to make. Another strategy, and this is more a strategy of deterrence, is if you have a U.S. subsidiary and the foreign parent is an additional insured under the U.S. subsidiary's insurance policy. If that's the case, the focus will generally remain with the U.S. subsidiary, and the foreign company can sometimes avoid litigation altogether because it's difficult to bring foreign companies into cases because of the jurisdictional reasons and because of just the hassle of going through the Hague Convention, et cetera. If there's just one pot of money and that pot of money can be accessed through suing the U.S. subsidiary, a lot of plaintiffs' lawyers won't even bother with the foreign entity. Of course, the key there is to make sure that the U.S. subsidiary has adequate insurance. Let's go to the next slide.
Okay, so the claims that are being brought, the lawsuits that are being brought, would come under two primary theories. One would be strict liability, strict products liability, and the other would be negligence. Strict product liability is a body of law that, while there's strict liability in other areas, the specific reason for it in products is to be a deterrent against defective products being manufactured. So what happens here is there's a lot less to prove than in a routine negligence case that you might hear about. So in a routine negligence case, you would have to show some elements. You have to show really a standard of foreseeability. You'd have to say, you know, was this problem that was caused by this food being imported, was it foreseeable? And did that, you know, essentially give the manufacturer or the importer, the distributor, a duty to the public or to the people that ultimately were injured? Did they breach that duty by not doing what a reasonable manufacturer, reasonable importer would have done to make this food safe? So this is negligence, right? Did they breach that? And by breaching that duty that they had to the consumer, did they cause some kind of damages? Did they cause injuries? Did they cause, you know, some of these cases cause some pretty severe injuries caused by food? Was it caused by negligence? Was this something foreseeable that could have been avoided, but they somehow acted unreasonable? Now, strict product liability is very different and much, much easier for the plaintiff to prove. All they have to prove is that there was a defect, that this product was somehow defective and it caused injury. They do not have to prove things like foreseeability or that there was a duty breached. They can prove that there was a defect in the design of the product, of the food product, the way it was manufactured, that it was mislabeled. This would be something that would go right to, you know, did this cause damages? There's a focus on designer and manufacturer liability when we talk about strict liability, and the question becomes, what about the innocent seller? You know, what about the seller who just sold the product that was distributed to them? You know, are they out of the strict liability chain? And that's where it becomes a state-by-state statute-specific question. You know, I have a seller of a product, and you know, this product, you know, would be strict. The manufacturer and distributor would be strictly liable because it did cause an injury. It was defective. But is there any way the seller could have known that? And in a lot of cases, the seller in that situation is protected from the strict liability statute. Now, in some cases, there's, like everything else in U.S. law, there's exceptions to the exception here. So you have the seller that looks to simply just be one more party to the chain that's selling this product, this defective product to people, to consumers, but they had a knowledge. There's some argument that they had a knowledge of the defect, or they, you know, and they should have warned. Maybe there was a failure to warn the community that there was this potential, at least, for an issue. So those might be exceptions. But if I guess the bottom line is if we have a seller, the question is, are they still subject to strict liability, or is there a statute for which we can get them out of that? Now, when you do have both of these theories, as you'd imagine, strict liability and negligence, which is most product liability cases for food or anything else, they would be both of these theories. The question becomes, since negligence is hard to prove, much harder to prove, there's elements here that need to be proven. When you get to a point of the case going to trial, or when it's going to trial, how do plaintiff's attorneys deal with it? And in a lot of situations, what they do is abandon the negligence cause of action and just go with the strict liability because it's much easier to prove. They can get right to damages and talk about how their clients were injured.
So piggybacking off of Joe and in the food context, and particularly for strict liability, the point is one can be liable if they sell a food product that is defective, even if they don't cause the product to be defective. And so if a supplier to a food product manufacturer provides a defective component or a contaminated food ingredient, the manufacturer that incorporates that defective component or contaminated food ingredient into the final product is still liable for injuries caused by that final product. And so the difference really is strict liability is not focused on fault. It's only focused on the existence of a defect which causes an injury. And so if food contains mercury contamination and children eat that food, that's it. You have a defect, it's got mercury in it. You have a cause and an injury. And since a plaintiff's lawyer will argue any amount of lead in food is injurious, you've now met all of the causes of action you need, or all the elements you need for strict liability. But of course, while that may be true, there are also very different types of injury. Even an undetectable injury that mercury might cause in a small exposure. And so what the damages should be as a result of this contamination, that's where the fight typically goes in food litigation. We can go to the next slide. So the main difference between what I would refer to as regular product liability litigation and litigation involving food, drugs, and medical devices is the involvement of the FDA. If there's an outbreak of some kind and it can be traced back to a food product, the FDA and possibly the CDC, the Central Center for Disease Control, will investigate and typically do what's called a traceback analysis. These investigations are quite intense, especially for the company that's being investigated. And these investigations, as well as prior FDA audits, investigations, and sometimes 483 letters involving a production facility, can have a significant impact in the incoming litigation. They can either help exonerate the facility, or they can help effectively prove that the cause of the defect is the facility. So let's say you're a food manufacturer in Italy. Let's say that the food you sold into the US is contaminated in some way. What is the source of the contamination? Did it come from your operation or one of your suppliers? If it came from a supplier, was this contamination a risk that you previously identified in a food safety plan? How was that risk mitigated? Did you follow your food safety plan? Did you rely on a certificate of analysis from the supplier regarding the component? Was it reasonable for you to do so? Do you have all of the documents relating to the supplier? Your qualification of the supplier as someone who could reliably provide you with this ingredient? Did you have some documentation that you can show that the ingredient that came to you was safe, like a certificate of analysis? These are all going to be some of the questions that the investigators at the FDA are going to be asking when the contamination is traced back to the facility. Of course, if there's some question about something that you or the foreign manufacturer or supplier should have done better or differently, the focus will also be on prior audits and investigations conducted by the FDA. Have you previously been warned about relying upon certificates of analysis from this particular supplier? Have you previously been asked to do some kind of intra-manufacturing testing, which could have caught the contaminant in the food before it was sent on to a distributor? Have you previously had to recall food products for any reason at all? As an aside, I will note that any prior recall is likely to have a very significant impact in the litigation if litigation is filed arising out of a contaminated food product. There's going to be a fight over whether evidence of that recall comes into the case at the trial of the case or not. And unfortunately, we've seen judges admit evidence of prior recalls in cases, even though those recalls have nothing to do with the case and the facts of the particular case. And so the existence of the prior recall can have a profound negative impact on a jury, as you might expect. Now, as lawyers of the company, we can spin a prior recall, especially if it was a voluntary recall. We can point out that the recall of a product is an example of a company doing the right thing when it discovers that there's something wrong with its product. But a prior recall generally contains or creates a very negative stain on a company, and it will be exploited heavily by the plaintiff's counsel at trial if there's an opportunity there to do so. And so if the contamination in this hypothetical case I've just been describing arises out of something that the company was warned about previously, or that involves something that led to a prior recall, this would be a significant bad fact in that litigation. In fact, it could raise the possibility of an award of punitive damages in the US. Remember, this is even if you're not at fault. The contamination came up through the supply chain. You're still potentially liable, strictly liable, that is, under US law, even if the contamination is not your fault, because again, fault does not matter in a strict liability case. And you could also be liable for negligence in this hypothetical scenario if the contamination is something that a jury believes you should have tested for but failed to test for. If it feels like, in this example, let's say there was mercury contaminating your food product, if they feel like you should have tested for mercury, even though you've got a certificate of analysis that shows that there's no mercury, then under those circumstances, the jury could find a duty to test and therefore liability based upon a breach of that duty under a theory of negligence. And so, as you can see, looking back at our prior discussion about jurisdiction, how important that discussion is. Because if you can avoid jurisdiction, you don't have to worry about US liability. However, if you cannot avoid jurisdiction, and as we've suggested, it's not easy to avoid, it's easy to see how liability can attach if something goes wrong and people in the US are injured or claim to be injured as a result of your food product. Let's go to the next slide. So let's delve a little bit more into the investigation undertaken by the FDA in a classic food contamination case. It starts with an outbreak of some kind. It could be a pathogen outbreak like Listeria or E. coli. It could be another type of outbreak like lead or mercury contamination in food. The FDA does what's called a traceback analysis, where they identify the same issue in multiple people and then try to trace back the cause of that issue in those people to a common source. And sometimes that's easy to do. And sometimes it's very complicated and there is no clear single source. For example, there have been several recent E. coli outbreaks traced back to fast food restaurants in the US. And the CDC can typically trace back a strain of E. coli based upon genetically testing that E. coli. So each type of E. coli strain has a genetic fingerprint. And this allows the FDA to say that this person's E. coli infection came from this particular source because it has the same genetic fingerprint as the other victims and going back to the original source. And so let's say we have 40 people with the same strain of E. coli and 35 of them at a McDonald's restaurant through a traceback investigation. There's a pretty good chance that the source of that E. coli came from food prepared at that McDonald's restaurant. And so then there is a further traceback to see if there's a convergence to one particular food or ingredient implicated at that McDonald's restaurant to see if the food item or the ingredient can be identified. If there's no convergence, then the FDA may identify a probable suspect food ingredient, but it won't actually be able to say for certain what the source is. And this gets to be very important when we get to lawsuits and lawsuits being filed. The plaintiff will all the plaintiffs in that scenario, they're all going to sue McDonald's. They can all say they got their E. coli infection from McDonald's. But if they want to sue the beef processor or the lettuce broker or the onion grower, a lack of convergence can make that case really hard for them. However, as we all know, that doesn't stop lawsuits from getting filed. And as we generally know, it's a lot easier to file a lawsuit and much harder to get out of one. And so we see these lawsuits against food manufacturers, importers, brokers, growers, and distributors. And the FDA investigation and traceback plays a very significant role into whether a plaintiff can actually succeed in that litigation. Let's go to the next slide. Even if the traceback is achieved and you can link the food maker to the defective product, you still have questions of medical causation and damages. Are the problems experienced by an individual consumer caused by the defective product or something else? Sometimes this is easy. The medical problem is basically somebody has a really bad case of diarrhea. They have to be hospitalized for a day, and then they go home. And the contaminant is E. coli. And they have E. coli from a particular fingerprinted strain of E. coli that's part of an FDA traceback to a McDonald's restaurant. Medical causation in that situation is going to be easy. But at the same time, what are the damages really? The person had an upset stomach and they went to the hospital. It's not going to be a high damages case. But let's say the person wants to instead link their E. coli infection with the development of a certain form of cancer. That's going to be a lot harder argument to make. E. coli is not generally associated with cancer. And obviously, lots of other things can expose a person to cancer. And so that's going to be a much more difficult medical causation for them to make. Let's say the issue is kidney function via a condition called HUS, which is a known complication from an E. coli infection. That's a much easier argument to make, but it may be subject to challenge also via medical experts, depending upon what the condition of that person's kidneys were before the E. coli infection. The more common the ailment, the more likely the defendant can argue that medical causation in a particular situation is suspect. And then sometimes, as we mentioned, there's no discernible injury at all. Let's take a mercury exposure, for example. If a person is if the patient is a child and there's a clear mercury poisoning in the blood from a significant consumption of a mercury contaminated product, that's one thing. But maybe the bulk of the persons consuming the product widely sold with a mercury contamination have no discernible injury at all. Maybe they had heightened levels of mercury in their blood that went down immediately after they stopped using the product. And there's no other symptoms or medical treatment that was undertaken with respect to them other than the diagnostic testing that showed that they had mercury in their blood. It may be down the road that the mercury exposure can lead to something, maybe the development of some developmental problem in that child. But again, that's going to be hard to prove from a medical causation analysis because developmental problems in children have all sorts of causes. In those cases, the damages from the exposure might just be the cost of medical monitoring for people who had a high exposure to that particular contaminant. And so even if you're a good manufacturer and you're stuck, there's a defect in your product and that product was widely consumed, you may still have defenses based upon potential challenges to medical causation and damages. And it may be the fact that many of the people that consume the defective product have no discernible injury at all. And we saw that a lot in the Daily Harvest litigation, which we'll talk about in a few minutes. Let's go to the next slide.
Another thing real quick on this one with the Daily Harvest litigation that we're going to touch on is one of the arguments we also look at is whether there was an idiosyncratic reaction to the individuals who got sick. And I think the most straightforward way to look at that is, somebody's liver, kidneys, whatever part of their body was injured, arguably because of the food, the product, just because other people's may have been as well, or you can trace them back to the same product. It doesn't mean that that person didn't have something that was tantamount to an allergy, something where they were somehow differently affected by that food product, similar to a peanut butter allergy, or some other type of an allergy, where their reaction was different from what could have been expected. And it was not because of a defect in the food or a defect in any of the raw products. So that's something that we look at the time as well. All right, so next, just to cover this quickly as we move through here, when there is a judgment against a foreign company in the United States, this is something that plaintiffs' attorneys generally dread, trying to collect in different countries around the world, trying to get a foreign jurisdiction to help them essentially. Getting a judgment in the United States and getting it perfected in a foreign country. there are issues as to whether a company or a subsidiary of a company might declare bankruptcy in the foreign country, whether there's a relationship that allows for a particular type of judgment to be enforced. There's issues that make it much, much easier and much more straightforward for a plaintiff's attorney to just execute a judgment in the United States if they have an American company that they can do this with. And that comes up, of course, in the context that Dan mentioned earlier, where the domestic company here in the United States has the foreign company listed as an additional insured. That certainly makes it easier, and that might make a plaintiff's attorney not concentrate so much on the foreign company to begin with. The other area where we see something here, where we're able to leverage these issues that they might have, is when there's insurance coverage. So let's say there's $1 million in insurance coverage, and the foreign company might have assets that, if it was an American company, the plaintiff would be more than happy to not settle within the insurance policy and be happy to go after the company for assets above and beyond the total insurance policy. We might have some leverage in these cases here to give them an American insurance policy and say, let's negotiate within that policy, or I should say an underlying insurance policy. Let's negotiate within that policy. And while it might not be what they're looking for in the ideal world in terms of a settlement or a potential verdict, it alleviates the chance that they might have to try to execute a judgment somewhere else. And I think for a lot of plaintiffs' attorneys, just the idea of somewhere else alone is enough that they're starting to look seriously at the insurance coverage. So that gives us some leverage.
So Joe's already talked a little bit about this, about the MDLs and the fact that food claims often turn into mass torts. Once you have an MDL in place, the typical next step is that after you have this consolidated group of cases, is that there's a selection of what's called a bellwether case, or a series of bellwether cases where the court either has a trial that the MDL court handles, or they send it back to another court where the case came from. Because when you have an MDL, not only do all the cases get moved to the MDL, but all future cases get sent from other federal courts to the MDL court, which here's the case. And I will add that there's usually a great deal of jockeying over which court gets an MDL, but that's could be the subject of a whole nother presentation. But once you have that MDL in place, the way they're ultimately typically resolved is through a set of bellwether trials. Bellwether trials are basically trials of representative cases, and we see what happens. If the defense wins a handful of bellwether trials, that's usually kind of the end of the MDL and the end of the mass tort. The plaintiffs aren't going to be able to prove their case. They've lost a couple of trials. They're not going to want to invest more money into more trials, and that's usually it. Meanwhile, if the plaintiff wins the bellwethers, then, again, that's usually it. Now we know that the defendant's going to be liable, and these bellwethers may supply a good sort of guidepost for what a case should settle for. If there's a mix of wins and losses, you might have to try more bellwethers to see what happens, or the parties may decide, look, we understand now what the risks are. We understand now what the verdicts are for the cases that the plaintiffs won, and they can maybe reach a settlement or resolution in that way. Sometimes, however, though, the bellwethers get thrown out before you even, or the trial, you don't even get to trial in these MDLs. For example, there was an MDL involving Zantac where there were over 100,000 claimants, and the entire mass tort got thrown out because the plaintiff's counsel could not prove through sound scientific method that the Zantac used was actually causing the cancer that was alleged. In another case in the Southern District of New York, there was an MDL involving acetaminophen. The allegation was that acetaminophen taken by pregnant women caused their babies to develop autism. And again, the court threw out that litigation because the science just simply did not support this claim. And so, as you might expect, food liability often will turn into mass torts, because once you start selling a food product that's got a defect in it, a lot of people are generally going to end up eating it, and they're going to have symptoms. Daily Harvest being a strange alternate example. But but as Joe just mentioned, based upon this idiosyncratic argument. But in any event, MDLs, mass tort litigation, it's very expensive. But we do want to consolidate cases typically into a single court because it actually makes it less expensive. You also, because you're consolidating all of your effort into one jurisdiction instead of spreading it out across lots of different jurisdictions. You also risk, if you have different jurisdictions, inconsistent findings of courts, inconsistent rulings on motions, on things like product identification or medical causation, and this can create a lot of headaches. So generally, everybody wants to consolidate, and so most people will agree to do that in many cases. Let's go to the next slide since we're running out of time. We frequently manage mass torts as consolidated, as what's called coordinating counsel for defendants. It's generally a good idea to have coordinating counsel for product liability generally around the United States to make sure you have a consistency in approach. It makes it a lot easier to manage them. Your coordinating counsel, when we're coordinating counsel, we're going to know how you store your documents. We're going to know how you have dealt with we're going to know and have dealt with your key employees. We're going to have worked with your employees on preparing them for deposition, and we'll have helped you identify good employees who can be corporate representatives in depositions. We will generally learn the positions you want to take in litigation, and we can ensure that you are taking a consistent position across all of the jurisdictions in which you may have litigation that arises. And then when you're dealing with a mass tort, you want to have a unified resolution strategy. If you've got multiple law firms, they may not be unified in terms of how they're going to resolve a mass tort. Is the decision going to be to fight because this is a bet the company proposition? Are you going to settle because there are documents out there that are going to expose you to punitive damages if they're discovered? If you are settling, how are you going to settle? What are the values that you want to settle for? Again, to ensure that all of this is consistent and unified, you want to have coordinating counsel do all of those things for you and manage a mass tort. Let's go to the next slide.
Something that comes up in these cases because of the number of defendants usually and the positions that the defendants are in, that chain of distribution that the defendants are in, is the risk transfer or loss transfer. And in keeping with moving this a little bit as time is becoming of the essence here, some of the things we should be looking at here are the contracts. Are there indemnity provisions going up the supply chain, or coming from up the supply chain? Does the manufacturer owe an indemnity and a defense? Should they be paying for the defense and the indemnity of the distributor of the seller? What do these contracts say in terms of indemnification? And how do they work when the state law, which there's different state law that around the country, around the United States, that applies to contractual indemnification? How does that work? And sometimes that makes a difference as to where these cases are best venued and what jurisdiction. The other question becomes common law indemnification, which goes back to just the particular jurisdiction's case law, and who would be defending who in the chain. Can we pass this off if we represent you as a distributor into the United States and there's a supplier that's above you, or a manufacturer? Can we get some type of common law indemnification based on the state law and the jurisdiction? One area that we look at here, which are often involved in these cases, are quality agreements and supply agreements. These are agreements that lay out the responsibilities to the end consumer. They lay out who's responsible for complying with regulations, who's responsible for safety inspections, who exactly along the chain is responsible for different items here. That becomes an issue more when we're talking about negligence, to go back earlier to negligence and strict liability. In strict liability, we might have an innocent seller, but maybe there's some contractual provision that talks about responsibility that contradicts that responsibility for inspections. And the same with the manufacturers and distributors. So I guess the bottom line on this slide would be to look at the agreements that are involved here.
So before we get to the final discussion about Daily Harvest, I did see a question in the chat I wanted to address really quickly because it goes back to the jurisdiction question. And then certainly if you have any other questions you want to put in the chat, we can answer them after the fact, or we can answer, Joe and I can answer them offline if you want to email us. The question was, does inclusion of provisions and distribution arrangements between Italian supplier and non-US distributors for non-US markets of language prohibiting resale to a US buyer or something like that, would that be something you would recommend to help on the jurisdictional issues? And I would say absolutely. If you are not intending to be in the US market based upon, and you want to be only in Canada or only in Europe or somewhere else, and you want to prohibit in your agreement sale into the US, that would absolutely be something we would use to show that there was no purposeful availment, no expectation, no decision, no knowledge, and no targeting of sending your products into the U.S. So that kind of agreement, and really papering any of your agreements, especially obviously when you're dealing with non-affiliates, those are all going to be papered. But even if you're dealing with your own affiliates, you want all of those agreements to be papered as well. Because those documents are going to show, number one, that you're not our alter egos, and number two, that you're not an agent. Because you'll want to have something that says that you're not an agent if you're the foreign entity and you're using a U.S. subsidiary, so that they're not acting on your behalf within the U.S. You want to stay out of the U.S. That's part of the reason why you have a U.S. subsidiary, and so you want to make sure all of that's papered, and those documents will protect you in these jurisdictional arguments. So finally, talking about the case study in Daily Harvest with the time remaining, I want to give you an overview of what happened in that recent litigation that Joe and I handled involving an alleged food contamination issue with a Daily Harvest product. So this was an outbreak that was traced back to what's called a leek plus lentil product, which was basically a salad topper that Daily Harvest was selling through its subscription service. We did not represent Daily Harvest. Instead, we represented a co-packer or manufacturer of the product. And so when the outbreak occurred relating to this product, our client's facility was thoroughly investigated by the FDA with no findings of anything wrong of any relevance. And so that was good news for us and our client. In fact, there was no identified contaminant in the product at all after the FDA and CDC completed their investigations. And instead, the problem, which was linked to heightened liver toxicity levels, was an ingredient included in the product called terraprotein flour. This ingredient was not contaminated. It was what it was supposed to be. However, it was a novel ingredient, and that ultimately was the problem. These high toxicity levels that some people were experiencing when consuming the product, it was alleged, created problems with their gallbladders. And something like 30 to 40 people alleged that they had to actually have their gallbladders removed as a result of eating this product. So these were potentially high risk, high exposure cases on an individual basis. And now Daily Harvest is a health food subscription service. And one of the things it does as part of it, for its customers, is it does include novel ingredients in its products. And so this terraprotein flour had a lot of protein in it. And so if you wanted to get protein without eating meat, this is a solution that Daily Harvest found for this product. And terraprotein had been used in food in South America and in a related product called Terra Gum, which is more commonly used in food in the US. However, terraprotein flour was not generally recognized as safe by the FDA. And generally recognized as safe is the source of what's called GRAS acronym. And to be sold in the US, food has to be GRAS, or else it's considered adulterated and not fit for sale in the US by the Food and Drug Administration. And many food items and ingredients are considered GRAS just because of their common usage. in the US over many years. However, if they're not considered GRAS or grandfathered into this sort of GRAS designation, there's got to be some scientific support for the idea that the food product is safe before that it can be sold as food in the United States. And Terra protein flour did not have this track record, and there was no scientific proof of its safety. And so the plaintiffs argued it wasn't GRAS. And based upon that argument, the plaintiffs had a pretty good argument that this leek plus lentil product, which contained Terra protein flour, was now defective. That was their argument. And their argument was that it definitely caused injuries, this heightened level of liver toxicity, and then the removal of all these gallbladders. And there was something like 450 people who were claimants in this. So it was a large number of people. But that was out of more than 20 to 25,000 units that were sold. And there was no actual scientific study or a link between this liver toxicity issue and this gallbladder issue and the Terra protein flour. It had never been developed. And so the only basis for medical causation were some epidemiological studies that were done by the plaintiff's lawyers and Daily Harvest. And so at the end of the day, something like between 95 and 98% of the people who ate this had no reaction at all. No liver problems, no gallbladders, no nothing. They were fine. And so this led to the question, did the Terra protein flour actually create a problem in the product? Or was this just what Joe was describing earlier, an idiosyncratic reaction by a handful of people? And if it was the latter, we had a pretty good argument that there was no liability. There was certainly no question that the product was labeled correctly. It did identify the presence of Terra protein flour in it if you read the label. And so, going back to Joe's example, if people had susceptibility to this ingredient, they could avoid it, like a person with a nut allergy avoiding eating a Snickers bar. And of course, a Snickers bar isn't defective because it contains nuts, even though some people are allergic to them. But the argument was the leek plus lentil Daily Harvest product was defective because it had this ingredient in it, which a small number of people had reactions to. And so that was going to be our argument, especially on summary judgment at the trial of it, prior to the trial of this case. But it was going to be a lot harder argument to make a trial, right? It's not our fault; it's your fault that you lost your gallbladder. Tough argument to make to a jury. And so when we had an opportunity to settle this case, we did. But before I get to that, let me tell you about the importer and the ultimate producer of this Terra protein flour. It did not come from the U.S. It came from Peru, and the company that sold it out of Peru was a company called Molinos. And an importer called Smirks was the one who brought the Terra protein flour into the country. And as you might suspect, Molinos filed a motion to dismiss, claiming there was no jurisdiction over it. But it lost the motion. And the reason why was because it actually met with people from Daily Harvest and targeted Daily Harvest, which was located in New York, with this product. And so they lost their motion. They were in the litigation. But going back to this leveraging argument that Joe was talking about, they had no money and they had no insurance. So at the end of the day, they were ultimately not the real focus of the litigation, and they were part of the settlement. And I don't know what they contributed, if they contributed anything. It was something very small to a settlement involving the importer, which was a U.S. company and basically used its entire all of its insurance to get itself out of the litigation. The interesting and unique thing that we did in this case, and I'll tell you about it, is we used a class action settlement, which is almost like a bankruptcy where you could get yourself, where you could avoid litigation, not only from all the claimants, but for all future claimants, subject to the opportunity to opt out. And so we use that process here, which is a relatively novel way to sort of get out of product liability litigation, because class actions aren't really appropriate for product liability litigation. But we use this process anyway, and the court bought into it. And so we were able to protect our client for the amount of its insurance from 450 claims and all the future claims that might eventually come out as a result of this. So I see that our time is up. I don't see any additional questions in the chat. We really appreciate the opportunity to present to you today. I'll let Joe give say the final words here.
Yeah, no, I just want to also say thank you very much. And Dan and I are here for any questions, anything that comes up. Our contact information is on the screen. And again, we want to thank Nick and Federico and the organization for this.
Yes, thank you. Thank you, Dan, and thank you, Joe. Lots of complexities, lots of jurisdictional issues. I think it's very clear that if there is an Italian company interested in distributing food products or any other products in the United States, that the most prudent thing for them to do is to seek guidance and advice. Insurance policies are key. Contract agreements are key. And your guidance, I think, is also key to their abilities to do business in a least amount of risk possible. So thank you very much.
It seems there are no additional questions, so I'll close this session, and you'll receive the presentation they just showed with their emails. So feel free to contact Nick, Daniel, and Joseph if you have any additional questions.
Awesome. Thank you for sharing, guys. Have a great afternoon, everyone.
Thank you.
You too. Thank you.